Alrighty, well, thank you guys for coming. Like I said, my name is Ashley Robinson. I am an attorney at Bradley's Birmingham office. I am in our intellectual property practice group. So I've been doing IP work now for about 3.5 years. I've been a lawyer for about 5. I did workers' comp defense work before. So I've kind of done a little bit of everything. When I was in law school, I would work a lot with entrepreneurs in the patent space and kind of do kind of a freedom to operate analysis and just kind of figure out, is this something that you can patent or not? People would come in with this like novel invention. They were so excited about it. And then you would go on Amazon and it's the first thing that pops up. And you have to be the one to tell them like, hey, this isn't a great idea. So-and-so already has this, whatever. So I've kind of done from that all the way up to the big corporations we work with at Bradley, and kind of everything in between. So hopefully what this is going to be is a little bit of a background into IP, just kind of give a broad overview. I know sometimes it's easier to kind of issue spot on your own if you kind of just have an idea of what's out there and what you're looking for. So hopefully I can kind of give that overview. Obviously, as questions come up that are applicable to you, please feel free to interrupt me. I mean, this is obviously a very small, this is for you guys. So if you have specific questions, feel free to let me know. I forgot to have a microphone on. So we'll kind of go through what is IP, the 4 main types, other things to consider, because it's not all just about trademarks and patents and copyrights, why you should care, and then hopefully we'll have time at the end for questions, or again, just interrupt me. So the first thing, what is intellectual property? Intellectual property is the protection of ideas and the expression of ideas. So there's the 4 main types: copyrights, patents, trademarks, and trade secrets. Those are kind of what everybody knows about. Those are the big things. And, IP is, yes?
Can we take pictures?
Yeah, sure.
Okay.
Yeah.
Okay.
Yeah. No, you're good.
We're recording this whole thing, so it'll be available for y'all to review.
Okay, cool.
Yeah.
So I
In
can
high quality. But you can take pictures.
I'm gonna take note, because sometimes if you
Okay.
don't know if I'm gonna see it again, I'm like, okay, I don't want to forget. But if I can see it again later, and I can just have some high points.
No, yeah, you're good to take pictures and stuff. So IP stands for intellectual property, obviously, but idea protection. And so it's the protection of intangible assets, essentially. So, you have your physical assets. If you have a business, you have the goods that you're selling. Those are your physical assets, your real property, stuff like that. IP is kind of what's in your brain, but it's the physical expression of what's in your brain. So you can't patent an idea. Everyone always asks, can you patent an idea? No. You don't have to have a prototype to patent something, but you have to be able to write in very lengthy words, describe to the patent office what your actual invention is. So IP, while it does protect your ideas, it more so protects the expression of those ideas. And that's your individual, artistic expression, or however it manifests itself. So the first one, and probably one of the most common ones for business owners that they think about, is going to be trademarks. And I've got trademarks/service marks. The trademark office, when they're looking at marks, they have different classes of goods and services that you can register your application in on a federal basis and state basis. And so if it's a trademark for a good, so say Apple registers their mark for computers, that's a good, but they could also register it for the service of an online retail service for selling computers or something like that. So that would be a service mark. You can refer to them both as trademarks. There's no issue there. But essentially a trademark protects any word, phrase, symbol, design, or combination of those elements that can identify to a consumer what your brand is, basically. And so the whole point of trademarks and the whole point of registering them is so that consumers aren't confused. That's what the trademark office is mostly concerned with, is reducing that consumer confusion. And so the idea is you create something that signifies to a consumer when they see your mark on a good, they know what quality to expect, they know what it's going to cost, they know where they can find it. All of that stuff comes from your marketing and your branding, which is why it's so important. And the goal is to reduce the confusion between those marks. So if you go and you have your mark and you register it, and then someone goes to try and copycat you, but they're selling kind of a knockoff brand with bad quality, you want to be able to stop them from doing that. And the trademark office would, be the avenue for doing that. So there's different types of, kind of different levels of owning a trademark. If you start your online business and you use your mark in connection with your goods and services and you go ahead and sell products, you have common law rights in that trademark in connection with those goods and services. Common law rights are very limited. So they're very limited geographically. So you're limited in your rights in the space that you're actually selling. It gets a little confusing with online businesses. The trademark office is kind of wishy-washy when it comes to common law rights, especially in an online business, because maybe technically you've sold it in Texas, but does that mean you only have those rights in that one specific tiny town in Texas? So common law rights are a little bit better for kind of a local business, something like that. It's very distinct where those geographic rights are. And you don't have to do anything to do that. You can go ahead and use the TM next to your mark, like a superscript or subscript. You have common law rights as soon as it is in use in commerce in connection with those goods and services. Now, the next level you can register at the state level. So it's $35 to register in Alabama at the state level. They don't do any sort of comprehensive search to make sure that you're not going to be infringing on anybody else's rights. So really you can kind of go in, register your mark, and you'll probably get, as long as everything is filled out in the application, you'll probably get your registration pretty quickly. So that's a little bit concerning with state marks, because if you haven't done your own kind of searching on the internet, I mean, just kind of type in like the names and the stuff you want to trademark, all that sort of stuff. Just kind of do a little bit of a background search before you go right to registering it at the state level. It does provide you statewide protection, but obviously, so that's more than common law rights, but it's limited to the state. But sometimes that's all you need. And $35 for a state registration can be plenty for a lot of local businesses. The next level, yeah.
Is that something that's required? Is that something that's easy for a business owner to go out and do on a website on their own, or is that something that we would need to reach out to a legal professional to do?
You can do it on your own. If you Google Alabama Secretary of State trademark, it should pop up and you should be able to register your mark. It'll have you put in the, certain owner information. The one thing you will have to decide what class of goods or services to register in. So it's the same classes as the federal trademark registry. So you can also just Google like USPTO trademark classes, and that should be able to kind of get you to where you need whatever you need to put in there. And then it will also ask for a specimen, which I think in Alabama they require 3. They can be exactly the same. I don't know why they ask for 3 when they give me exactly the same. But a specimen is basically just an example of your mark in connection with how you're using it in commerce in connection with your goods or services that you've applied for. And so if it's a good, it's typically best to just take a picture of your mark on the actual item. Yeah. Websites can get a little confusing. You need to be able to show that you're actually like selling it to consumers. So services can be really hard to show. Yeah. But if you can show your product with a label on it that is primo specimen, like send that if you have that. The federal level is $325 per class of goods or services. So you can put multiple things within a class. So I can't remember the number, but one of them is kind of clothing. So you can do t-shirts, sweatshirts, pants, whatever. That's all in one class. That's all one application fee. Okay. But if you were to do t-shirts, sweatshirts in one class, and then the online sale of clothing, that would be a separate class. So that would be $650 total.
What would be the difference between needing the state and federal?
So the federal is going to give you nationwide, the ability to enforce your mark nationwide. And it gives you a lot more presumptions if you go to court. So if you've registered your mark, it's presumed valid. You don't have to prove it's a valid mark. So in common law scenario, you would have to prove your use in commerce. You'd have to, all the stuff that comes along with a federal application, you would essentially have to prove for your common law rights to use it in court. So you just kind of have a better, and this is not anything special, but you can put the R, the registered. So once it's actually registered, you can put that marking on your, wherever you use the mark, and that alerts people, like you've put everyone on notice, which is another thing that you can do with your mark. It just really bolsters your ability to enforce your mark. And one thing, well, with all IP rights, just because you have a trademark registration doesn't mean the trademark office is going to go out and tell people to stop using your mark. You are the one responsible for enforcing your mark. So whether you're enforcing common law rights, state rights, or federal rights, you have the obligation to go out and enforce your mark. And so if you have a federal registration, you can obviously send a cease and desist, slap that certificate of registration in there and say, you're using our exact same mark on our exact same goods and services. Like, we're the senior user, stop. Or we're taking you to court and we're going to get whatever amount of damages. So it just gives you a much greater level of protection and ability to enforce your mark at the federal level.
Is that retroactive?
In a way. So when you register your mark, and there's two types of registrations. You can do use-based registration, which you're already using your mark and you put your date of first use in your application. So you can file your application. Say you file your application today, but you started using your mark 3 years ago, you can put your date of first use as 3 years ago. And that means that your mark is enforceable. You can jump somebody who's filed later, used later, and if you can prove earlier use, you can have their mark canceled and your mark can be registered. So
Retroactive from the standpoint of they've been using the mark, we didn't know about it. They made a certain amount of money, right? Can we retroactively present, hey, we had this, can you get money, can you sue them, or how's that?
Mm-hmm. But you don't have a registration, is that what you're saying?
No, you do have one.
Yeah, so it just all depends on who started using it first. So that date of first use is super important. But also your filing date can come into play in certain instances. And if you know within the year, I know, like, I'm setting up my business, I've done my branding, I know what it's going to be, I just haven't actually started selling the goods, you can file an intent to use application, which says, I have a bona fide intent to use this mark in commerce in connection with these goods or services within the next whatever months. I think you have up to 36 months to show use. So that can kind of give you a little bit of leeway in, you don't have to necessarily be using it the moment you file your trademark. That's a little bit nuanced. So if you're considering that, I mean, that's probably when it's worth talking to an attorney, if it's not just like a standard trademark application. We kind of talked about the classes, just you register within a class of goods or services, and then the markings. TM is fine to use as soon as you start using your mark in commerce, and then the R would be, the R with the circle is what you can use after you've actually received that certificate of registration from the trademark office.
So you mean TM as soon as you file? Is that what you're saying? Prior
Today you could use it. You don't have to file anything.
I can go find a little thing.
Right now.
Right now? Okay.
Yeah. And it's really good to do that because then you're putting everybody on notice, like, I have trademark rights in this, I intend to protect them, like, everybody's on notice that that is your mark.
I don't think I knew that. That's good to know that
Yeah.
those symbols are a, hey,
Yeah.
this is a warning, symbols,
Yeah.
like good words. I love that.
Pretty much.
I did have a question about the
Yeah.
classes. The
Okay.
example that you gave, I guess can you further explain why you would put something in a different class?
Yes. So when the trademark office looks at a mark, one of the things it looks at, say we're going to talk about federal registration here. So you filed your mark with the USPTO and you filed your mark for, something to go on t-shirts, sweatshirts, sweatpants. And someone else has filed that exact same mark looking exactly the same, but they've filed it for use and sale with pharmaceuticals. The trademark office is not going to find an issue there because those are going to be going to different consumers. The consumers are not going to be confused by those two marks. So that's the importance of the different classes. So because you're only because you're not selling, you only register your mark in connection with what you're selling,
Sure.
what goods or services you're selling. And so it's a nuanced way. Either that can help you when you're trying to register your mark and there's something that's confusingly similar and the examiner says, no, we're going to refuse your application. And you can say, well, no, we're not selling to the same consumers. We have completely different goods or services. So that's irrelevant to this. They can look exactly the same. They can sound exactly the same, but the consumers are completely different. The services are completely different. So let our mark register.
So essentially, like, if you're going to use it in different areas, you need to file for each class. So it's like, hey, if I'm going to put it on clothes, I need to file in that class. If I'm going to use it on packaged food goods, so whatever kind of product you're going to put it on, you need to file for each class. Otherwise, it won't be protected or it could be up for debate.
Yeah.
Okay.
Yeah. But, with a smaller business, there's the consideration of what's going to give you the most bang for your buck. So if you only want to file one application, and you don't have to file them all at once. So you can file one application to start on your main product, and say your business evolves later on, you can file another application later in a different class. That's totally fine. It can be the exact same mark in a different class. You can just kind of add to it as you go. It doesn't change the price of it. It's still always $325 to register in a different class. So.
Question. I didn't know about the intent prior to today. I mailed like my logo, what I was using, the name of the brand and all that to myself. I didn't open it. So can I take what I didn't open to like court and say, hey, they're using my information? Or is that like not a thing?
That would be more for copyright. So trademark has to be consumer facing, essentially. So if you're not using it in commerce, you have to have actual interstate use in commerce to be able to federally register your mark. So if you haven't started yet, and that's just kind of your design, your ideas for your branding, what you're about to do, then that's more of a copyright issue. And that date would be your date of creation that you could use on a copyright basis.
One more question.
Yep.
I know. So I'm curious to know, like, with trademarking those ideas early on, like how it could accelerate innovation in just various communities. Like, could we possibly like explore that?
So do you mean how it would help those businesses, or?
Like, what could a potential initiative look like? Just trademarking, just say if you have 50 to 100 people, like how could trademarking their ideas early on like really accelerate innovation in the area?
Yeah, I don't know that a trademark itself would necessarily accelerate the innovation, because it's all about kind of your branding and your ideas. So it's one of those things like, yes, it's worth having a trademark, but they're really worth a lot if you're Walmart, if you're Target, if you're Apple, if you've created and cultivated this brand. And so that, I think if you were to have some sort of like innovation area where you're pouring a lot of effort into helping people create a brand and helping people create goodwill associated and promoting that, that would be worth getting a trademark and kind of doing that process. But I don't know that it would really be worth it just kind of for a general set of, businesses or something. I don't know that the trademark itself is going to actually help the innovation. But it would, if there is a business or, an organization or something that really pours a lot into helping with branding and helping with marketing and all that sort of stuff, then it would definitely be something to consider as part of that kind of baseline of that program. This, I was just kind of like to mention, if you are coming up with your branding or coming up with a logo or thinking about rebranding, the trademark office has, along with its likelihood of confusion consideration with what's already registered or applied for, it looks at how strong your mark is before it will allow things to register. So generic marks are not allowed to register. And a generic mark is going to be something like the bagel shop for a bagel shop. You can't trademark that. Everyone else has to be able to call their bagel shop a bagel shop. So the trademark office is not going to let you trademark that. So now the whole design and everything, if you do in color and with the bagel, all of that, they'll probably let you register that, and you just have to disclaim the words, which just means I only have protection of these words in use exactly like this. Descriptive marks are a little bit stronger. I have seen recently so many descriptiveness refusals from the trademark office. I think that's just kind of something they've decided to really like hang their hat on for whatever reason recently. It's kind of annoying because some of them don't actually seem like descriptiveness refusals, but kind of is what it is. It's not the end of the world. There's something called a supplemental register, which you can register descriptive marks on. And then basically after a certain number of years, which I can't remember right now, you can move to the principal register because you've acquired distinctiveness. But examples of kind of descriptive trademarks would be creamy for like a yogurt product or something like that, or bed and breakfast registry for obviously a bed and breakfast type online registry. So if you can, absolutely stay away from generic marks. Try and stay away from descriptive marks. Suggestive is strong. Those are allowed to be registered. So that a suggestive mark is something that's going to kind of suggest to a consumer what the goods or services may be. And so a good example of this would be like the copper tone sunscreen or tanning products. So they suggest kind of a golden nature of your skin, you know, in the sun. That's what their whole thing is. That's an example of a suggestive mark. And then fanciful and arbitrary are the strongest. So fanciful is a made-up word. So Exxon for gasoline or Pepsi for Pepsi products. Arbitrary is Apple is a great example of this. Apple obviously is a type of fruit, has no relation to computers or any sort of technology. They decided that was their brand, and it's arbitrary, and it's become super, super strong. So that's just kind of, if you're thinking about rebranding or thinking about, you know, coming up with your brand, you don't already have something set, this is important to consider. Now, I talked about one of the things that the trademark office looks at is likelihood of confusion. And one of the easiest ways and free ways to just kind of do a very baseline check on making sure a mark you've decided to pursue is going to be okay based on what you're able to look at is one, a Google search. Do, you know, various forms of your mark with descriptors of your goods, different areas, all that sort of stuff. But the second step would be the USPTO's trademark database. So if you just Google USPTO tests, something like this link should come up. And you can click on that and go into the trademark database. And then you can click on trademark search system and it'll take you into the actual database. The USPTO website is one of the world's most confusing websites. It's just, you can get lost in there. So this is how I do it because I have no idea how to find it just from their website. This is the actual search page. So what comes up when you click on that will be, you know, a little box and you can put in your mark. You can put in different variations of your mark, different phonetic spellings, kind of think about how would this, if I'm, you know, if it's going to be spelled differently, should it be with a C, with a K? Search it all those ways. Search it, if it's one word, search it in 2 words, just to see, make sure you're kind of capturing everything that a trademark examiner might see. So you can put, I just do it from the Nike slogan, just to search, and I hit expert. And I've done just the live marks, which are registered and pending marks. Dead marks aren't going to impede your ability to register your trademark. So you really only care about the live marks. These are going to be actual registered marks, which have, have gone through the whole process, have been approved, and pending marks, which are in process for whatever reason. Maybe their application is just pending. Maybe there's proceedings or something going on. But those can still be a bar to your registration. And then on the far side over there, under class filter, are the different classes that you can click on. And so again, if you just Google like trademark class searching database or ID manual, you can look at those. You can kind of get an explanation of what the classes are. I will say also sometimes for a starting point, you can put in like ChatGPT or something like that and say, these are going to be my goods, what trademark class, see what it tells you, and then go in and follow up and double check in the trademark manual. But it gives you kind of a good starting point because the classes are kind of just bizarre. Like they'll have a 3-word descriptor of what the class is, and you're supposed to know that your subset of goods goes in there. So sometimes if I'm stumped, I'll just put it in ChatGPT and get a starting point and go look at those classes and see if it actually matches what I was trying to tell the AI. So this is a good way to just kind of double check that you're going to be okay on a trademark basis. Does anyone have questions about using this? It's relatively user-friendly once you kind of get in there, and you can click on these and you can go through the different applications and you can kind of see. Also, I would say if your good is similar to kind of a mainstream good, so some people came up with like essentially a dating site for jobs. So we looked at all of the actual dating sites to see what their marks, how they described their marks, so we could try and figure out how to describe our mark off of that. So if there's a good out in the marketplace that's similar to you, especially like a big name brand, go in and look at their application and see what they've put in for goods and services. See if they, came up with any issues or anything like that. Go in, and it's a very helpful place to kind of get started and get your bearings on what you should do for your mark. Yep.
So as long as when you put whatever your business is in there, it's not trademarked, you're good.
It's best to go ahead.
You're better off. You never know if you're always good or not, because you could do it one day and a week later, you go to file your application, and in the interim someone's filed something. The trademark office will look at this. They will also look at just common law records. So that's a Google search if there's a business in your area. And so say, like, I'm trying to think of an example, but say your mark is like apples and oranges for technology. That's probably going to be considered confusingly similar to Apple. So it doesn't have to just completely match your mark. If there's some sort of confusion around what the mark may be, then the trademark office may cite that as a objection to getting your registration.
My question was, I know too, you had a slide where you're going to walk us through why this is important. So that would be super helpful. This is a personal question. So, like, would this site be useful for me? So our company, the building we're in, is called Polaris Birmingham. There is a Polaris company that does like tractors, and we get 50 calls a day. And they're like, I'm trying to fix. I'm like, ma'am, I can't help you with a tractor. If you need some working space, I got you. And so there's confusion because of the name itself. And I think their headquarters is here in Alabama. It's in Huntsville. And so then ours is around kind of like this interstellar space thing. Theirs kind of had the marks aren't the same, but the name is the same. But ours is Polaris Birmingham. And so we get a lot of confusion when people look us up. And when you put both our names, the name in, both of them come right up. And people are just moving really fast. They just don't,
yeah.
So I was concerned, like, as we grow, do I need to consider like changing the name? But then there's like the local piece that you made mention of. But if we go outside of Alabama, right, and we want to help people in Tennessee, like, would this be a good place to start? Because I know our goods and services are different, but the name itself causes confusion because we get 50 calls.
Yeah, it is hard when your goods and services are different, because you just, the analysis, the likelihood of confusion analysis is similarity of goods and services, similarity of the mark. And if the mark is similar but the goods and services are completely different, it's not really, I'm trying to think like exactly what you could do.
And then I also just don't want them to try to sue me.
I was going to say, have they been around longer than you have?
Absolutely.
Yeah, so that's the other problem. But I think that because your goods and services are so different and your logos are they different? I mean,
they're different.
Yeah.
They're different, yeah.
So then I think that it would be, they can send you a letter, but they have no.
Okay. I'll tell them to call Ashley.
Yeah.
So, just so I understand, if we came up with a football program called Apple, it's Apple. Apple could, even though we're in football and they're in tech, they could come back and sue us. Is that what you?
I mean, they could, but I don't think they'd really have a basis for that, because, I mean, the more famous a mark is, the more leeway you get. So that's kind of one thing to consider. I mean, I don't think I would want to go up against Apple. But, football and tech services are completely different. Now, there is a chance that they have registered their Apple mark in connection with the sale of, footballs, baseballs. Then you might have an issue. So that's another thing. I mean, they can file $325 is nothing to them. So God only knows how many applications and registrations that they have and what classes of goods and services. You do have to continuously use it in connection with those goods and services. And so, that may not be something they're doing. But yeah.
So I have a trademark for my publishing company, but I've always just kind of questioned what the reality would look like if, just say, the company takes off and it's only trademarked in Alabama. Like, what would that reality look like for somebody that wants to use the materials or just the things I'm creating? Before I get enough money to trademark it federally.
So your mark you have it registered in Alabama? Okay. And you're concerned that if you were to expand, someone outside of Alabama would use your mark kind of...
various ways.
Yeah. Just because it's... I'm trying to think exactly the best way to go about dealing with that. I mean, I mean, there's going to be different ways of dealing with it. So it depends on if they're using your exact mark online, then there are certain copyright issues with that. So maybe it's not necessarily a trademark issue because you don't have a federal trademark registration, but maybe it's a copyright issue. Or maybe, they were supposed to be working with you and instead they've taken your mark and they've run with it on their own and we can fall back on a contract problem or something like that. I don't know, like an Alabama state trademark is not going to necessarily help you in a different state. It might lend support to your argument, but I don't think you can enforce that in Alabama. So, but if you've used your mark out in wherever they're using it before them, then you have your common law rights. So,
Yeah, like somebody in another state could pretty much take the same name and create resources, and I would just have to deal with it until I federally do it right.
yeah, but copyright protection is a good way to deal with stuff like that. And so we'll get to that. I think it's next. And we can kind of get a little bit deeper into how you can kind of use copyright to kind of fill in those gaps where trademark law doesn't actually work. Trade dress. So this one, because we talked a little bit about like fashion. And so trade dress is a type of a trademark, but it's the visual appearance of a product or packaging that identifies its source. So obviously that's the Tiffany's box. This is what they registered. This is their trademark. That blue in that box, the shape with the bow. So it is that blue and the way this box is and all of that is their mark. That is their mark of their brand. It's not functional in any way. They didn't trademark the actual box and with a lid and a bottom and all of that. They trademarked literally what it looks like. And you can't really tell, but there's dashed lines like around the box. So it's really just the blue color. That's what their trade dress is. So, and then this one obviously are the red bottoms. So this is dotted. So it's not only just this shoe. So they've registered it women's high fashion designer footwear. So the red bottoms in that class, and they very aggressively protect this mark, as I'm sure you can imagine. And so, when you see the red bottom shoes, you know exactly the quality and what they are. It just immediately directs your mind to that brand. And so that's how trade dress can be helpful in kind of different, ways, sort of fashion way. I know that might be applicable to some people. So I just wanted to make mention of that so that if that's something that would be helpful. But it is purely aesthetic. It is non-functional. Any sort of functional stuff would be like the patent world. Copyright. So copyright is different from trademarks. Copyright is going to protect anything that's original, fixed in a tangible medium of expression. So it has to be fixed. It can be a video, it can be words, it can be a poem, it can be a sculpture. Anything like that is copyrightable. And like trademarks, as soon as you put it in a fixed medium of tangible expression, you own the copyright in that expression of the work. And you can go ahead and put that C on it. You don't have to do any sort of registration with copyright to use this C. So this is a really good way to protect your marketing materials. Or if someone is using your mark and it's not trademarked, you have copyright rights in that mark. And it just has to be, the test is a little bit different than trademarks, but still if it's, virtually identical, all that sort of stuff, then you can enforce your copyright rights in that. Yes.
So, but a logo is trademark, not copyright, correct?
Both.
Okay.
Yeah. So you would have the trademark would be in reference to the actual mark in relation to the goods or services to the consumer. The copyright is going to be your logo.
So
just
one's like the use, and then one is kind of like the
visual expression. Yeah.
Okay.
Yeah.
So for example, we're a nonprofit. Our trademark would be more in the sense of services that we provide to students.
Yep.
So if you just see the logo itself, which one do we need? Do we need a copyright or do we need?
I would use, if it's going to be your actual logo, I would put the TM on it. But just know if it's not actually registered, if someone uses it out of state, you can pursue copyright protection from it too. It's not, they're not mutually exclusive. Yeah.
Okay.
Yeah. So yeah, your copyright would be in the reproduction of the actual logo. That would be the issue. Trademark would be someone else is using your logo and trying to do your same services.
Got it.
Yeah.
Got it.
So yeah, so if you come up with any sort of employee training or like a video production that you create or, you know, some stuff on social media or something that you've created, it's your original expression of your ideas, that is automatically, as soon as it is fixed, you hold the copyright in that. Yep.
I'm sorry, I didn't want to.
No, that's okay. Okay. This might answer the question. You do not have to register your copyright to hold the copyright in it. However, you do have to register it to pursue enforcement of your copyright, but you can retroactively register your copyright. So you do get certain benefits from registering your copyright as you create it, which just basically includes increased damages. But that doesn't mean you can't get any sort of damages if you retroactively register your copyright. And I think it varies on what it costs, but I think it's like $35 up to $200, depending on how many and the type and all sorts of stuff. Because obviously you could do a video, or you could just do like a brochure or words of a poem or something like that.
The question I had, I don't know, hopefully this isn't jumping too much. And in the world of AI, everybody thinks that they're creating something original, and they're not, right? So you have people who are taking some of their ideas, putting into AI, creating things. How does that factor into that? And I know that's probably like what the legal world is navigating, because you have people who think that they're protecting an original work and they're not. And so how are y'all navigating that?
So it's probably gonna take the courts like 50 years to figure that out, because they are so behind on everything. But yeah, that is something to be very, very careful with, because the issue a lot of people are seeing is, so these AIs have, a bunch of books that they've read, and people will go in to create something new, and they'll say created in the style of so and so or whatever, and it pumps out something that is not really new. And so I would very much caution you on using AI and kind of putting something out as yours when something of that nature. I mean, obviously like a social media post or like discussion points or something like that is different. But if you're going to put it out and say, I wrote this book, I mean, don't do that. Just write the book. And I mean, it's a very big issue right now. There really are no answers. The USPTO has said, and I haven't recently checked, so things could have changed, but they're having big issues with people, especially with like source code type stuff. Like you're not able to, you have to disclose if you've used AI, and you're not able to patent stuff or copyright stuff if it's got a large amount of AI. You have to be the creator of it right now, is how it's working.
And I just wanted to note that, because I know that, it's a push to use it. I mean, I use chat, for different things.
Yeah.
But I think it's important for us as business owners to note that it's still important to use your creativity, and then consider what that looks like from a legal ramification, and not put things out as your original work. Like, you can share things, but if you try to sell something and protect it, like, just know it's just don't work.
Yes. That is a very good point.
So I use AI for a lot of my materials, and when I began to study AI, just when it first came out, I learned that AI is pretty much just this huge data set that is pretty much like an advanced search engine. Like, ChatGPT is pretty much like Google. It's just that Google is not going to organize information. Google is probably going to just direct you to 30 pages or 30 sources, but ChatGPT is pretty much going through that intelligence, analyze it so much and kind of give like a summarized, I guess, response to resources that's already out there. So I'm still trying to navigate just what that looks like as far as just how all that works as far as,
Yeah.
Well, just the point with AI is to remember that it's also learning. Generative AI is learning from everything you put in. So if you give it something that is yours, then it's gonna show up somewhere else. So you would have to, as a creator or business owner, be very conscious about what you place into any of those systems, because then it's gonna come up. And in education, one of the things we're looking at is, so you can't put any personal identifiable information or anything, because it's gonna learn it.
Yeah, that's like with the law. We have to be very careful what goes into these public databases, because you can't just put your client's information there and be like, if I have a client that does this and then we have this problem, like what's our best defense?
Right.
I can't do that. And it makes up, I'm sure you've seen, it makes up cases all the time, which is like bizarre, but it has to give you an answer. So it just like makes up a case. And there's been a lot of attorneys that have put that stuff before a court and been in big trouble. So be very careful.
One I was going to actually ask, because I did a couple of AI classes a couple of weeks ago, and I guess what they're saying is if you have the paid version and it's yours and then you teach it about your business, then it doesn't share it. But how true is that actually?
Yeah, I'm not, it just evolves so quickly that truly I have barely just remembered to start like using it now. I'm like, cause I kind of just, I'm doing my own stuff and I forgot it was there to help. So, I mean, I do think that like the paid versions, I would just assume anything you put in there is going to go into public domain. I wouldn't assume anything that you put in there is private. Yeah. Yeah, I don't know all the specifics, but my assumption would just be, if it's something you want to keep secret, don't put your trade secrets in ChatGPT, please. For the love of God, don't put your trade secrets in ChatGPT. They're not secret anymore. And that goes to the point at the bottom. If you register a copyright, it will be public. Do not register copyrights for your trade secrets. If you're going to hold as a trade secret, like the secret sauce recipe to your family's barbecue sauce, do not copyright the recipe because it will be public. That's just a note. This is just a little bit more. You get the exclusive right to reproduce, prepare derivative works, distribute copies, perform, display, whatever you register.
So question real quick, just how far do you think you guys, when we come to derivative works, how hard would you hold us down in that world?
That's a hugely factual area of copyright law. And so it kind of depends on, the judge you're before, the jury that you have, the facts you can pull. I mean, it's super fact dependent, and also probably depends on how much money you want to spend and who are the players. Apple is probably going to spend a whole bunch of money to protect something, versus if it's two smaller businesses, then you can probably end up at some sort of settlement or something like that before you even see a trial. Or maybe a cease and desist letter and a settlement before you even file the complaint will work. So it's super fact dependent. If you are going to do, if you're going to take someone's work and then create a derivative work, just make sure it's actually different. Like, if you take a poem and you reproduce all the exact words, but you change, the display, that's going to be a derivative work. You've taken all of their words, that's not going to save you. It really has to kind of have your own creativity infused into it. And again, copyright is largely about the expression. So if you take a set of words and you put them on your marketing brochure in a certain way, a certain arrangement with certain colors, and then the next year you do it differently, those are probably going to be two different copyrights. If the words are exactly the same, then maybe, whatever. But it's the actual expression, not the idea or the concept of what is produced. Trade secrets. Basically, they're kind of self-explanatory. It's trade and a secret. So it's got to be something that has value that you use in your business, and it's got to be kept a secret. So it has to have economic value, and it cannot be publicly known, and you can't be able to kind of reverse engineer it, really. If someone can figure it out easily, it's not a secret. So these can be big in, and I'll put the examples up here. I think we might have some people that do food related stuff. So that's probably one of the, just kind of a standard examples, like the actual secret sauce. So the Coca-Cola recipe is a trade secret. There's huge economic value in that. It is kept a secret and no one will ever know. I don't even know how many people there are that know what the Coke recipe is. So there's all sorts of different things, different ways you can go about maintaining a trade secret, but limit the number of people that know what the actual secret is, put it behind a password protected door, put it in a locked filing cabinet. Don't tell anybody, tell one person where it is. If it's an online thing that you can access, make sure that only certain people, it's password protected, all that sort of stuff, that if it comes out, say someone was at the Coke factory that knew the recipe, they left Coke, they went to Pepsi and they said, hey, we got this recipe, let's change this. The reason that Coke, now the recipe would not be a secret, so that's what they're like, it's, they stole this, they've told everybody it was supposed to be a secret, they signed all these contracts that they agreed that they were going to keep it a secret, blah, blah. Where was I going with that? Lost my train of thought. To pursue it in court, you would have to show that it was actually a secret. It did actually have economic value. You'd have to go into every sort of protection that you had protecting this. They probably show to the court a log of everybody that accessed. I'm sure that it's in digitalized now, so maybe there's a log of every person that accessed it, and it was a set of 3 people that had the password. All of those things are really important, and it's really important it's kept a secret. So this can also be like vendor and supplier information, if that's really important to your business, who your customers are, what your price points are, all that sort of information can be trade secret. So but if it's going to be protected as a trade secret, it has to be treated as a trade secret. And so that doesn't mean everybody in the company has access to it. Production know-how, if you've got sort of an assembly line of certain steps, the way things are done, all that sort of stuff. Anything that basically can't be patented, copyrighted, or trademarked can be a trade secret if it has economic value, and it can be kept a secret. So it's something to consider because you do have to actively protect it.
Can I ask a quick question?
Yeah.
To keep us in one spot. Like with the vendor and supplier information, like what kind of businesses have you seen utilize that in terms of tracing? Because I think now, right, like everyone wants to share data and your spreadsheets and who's your clients. You have YouTube where we're sharing how we do things all the time. But like vendor and supplier information, like what kind of companies or
I would say it's probably larger companies that have like nationwide sales, or so, like, steel suppliers or something like that, where they have their personal contacts of people at the suppliers or people at the vendors, and they have that sort of information because that gives them a leg up over their competitor.
That particular vendor helps them to keep their quality.
Yeah, and I think that that would probably be less applicable to a smaller business, because kind of how you get your smaller business going is by working together with people and sharing that information. And I think it's a little bit of a different. I think it's probably more very large company where there's 3 or 4 market players, and it's really important that information stays secret. And so think if the CEO from this company goes to this company and he takes all that information, he takes everything from that company to his new company. And so that could be super detrimental to his original company. That's kind of where that comes into play a little bit more.
I knew a guy who went to war with Saks because he worked there and he started a business. And I probably overlapping of clients, and they took him to court. He had to give his whole laptop, Rolodex, all that because of the competition. So I think that's kind of what that is.
Yeah. So that's probably where that's more applicable. But like pricing structure, that could be important to a business, just to kind of have your whatever, so your competitors don't know exactly how you price things, all that sort of stuff. Patents. I don't have a lot on patents because they're getting really, I think people think that patents do a lot more than they do. So especially now, I mean, a lot of things have been patented. That doesn't mean to say that new things can't be patented. They're patented every day. But I would caution people on just pursuing a patent to have a patent. Sometimes it looks really great in your investment portfolio. And you can say, I've got 3 patents on my goods, and you can put that before investors, and they're like, okay, yeah, that's cool. You pursued 3 patents. You have 3 granted patents. That's awesome. Sometimes people will pursue a patent just to be able to put patent pending on their product. That can also be helpful to some people, and it can kind of discourage competitors from encroaching on that product because they're like, well, they're pursuing patent protection. We don't want to get caught up in that. We're just going to go a different way. So if you filed a patent application, you can put patent pending on your product. So sometimes people file their application with no intention of going through with the patent. So there are ways that they can be very useful. But if you've got, one idea that is some novel idea and it does meet all the qualifications for a patent, and you're like, well, do I pursue a patent or do I not? I would really consider what you're going to get out of a patent. It could be a very narrow protection, and in that case, you would just have that, your one very specific item that you've patented, and that's all you have protection in. So someone can change it a little bit, and then it's not infringing on your patent. So they can be very important to certain businesses, but I think, and they do cost a lot. So it might not be the best investment to pursue patent protection, but it's the right to exclude other people from making, selling, or using what you have actually invented. Yes.
Do you have a hand too?
Aaliyah, yes.
Oh, no.
Okay.
So I've learned that, because I got a few documents of just patent descriptions, much like a patent overview of things I plan to patent. And I guess my direction is trying to license the technologies that I patented to major companies. And I think for me, that's my approach. Like when I do file it, I'm looking to go through a licensing type of approach to make sure if companies want to use this particular technology, because I have the patent, they can either license it from me or they want to, just things like that. So that's been my approach.
Yeah, that's definitely, and I think I had that on the last slide, like why is this important? Licensing is a huge reason IP is important. You can be a smaller business and you come up with patents or you come up with the trademarks and branding and whatever, and some big company comes to you and say, we'll buy this for X amount of money. You have the option to sell your assets. It's not just your physical assets. It's not just your storefront and your furniture. It's your actual intellectual assets, and those can be very valuable. So that is definitely something to consider. You can absolutely license them. You can sell them, all that sort of stuff. A type of patent that might actually be relevant, and they are way simpler. So a normal patent might have anywhere from 10 to 20 to 50 different claims on it, claiming all sorts of nuances of the this structure and that structure, whatever. It's like reading a foreign language, and writing a foreign language. But a design patent protects the ornamental appearance of a product. So similar to trade dress, but trade dress is again very on a brand. So the color is the brand, or the shape or whatever is the brand. A design patent is similar, but it's not about what the consumers see. So you don't have to have that extra element that you do have to have for a trademark. So, and it's kind of hard to see, but this is like a design patent Nike has, and they've patented this kind of arch here on the shoe. So all this dotted line stuff is not patented. That's just to show that it's on a shoe. And so their claim is, I think it's like the ornamental, what is it? It's so hard to read. But it's like one sentence, and it says the ornamental design of a curve on a shoe, or something to that.
Else could make a curve on a shoe.
And
Like that.
yeah, like this. Yeah. So, and they're a little bit hard to kind of explain, and a little bit hard, honestly, to understand for me as how you would actually go into enforcing this. But it really would be, if someone has a knockoff shoe, that's going to be your best protection of, enforcing, like, no, we have a design patent in that, so you can enforce your rights in that.
I had a question too, like, because to your point, we had a fashion innovation panel a couple days ago. Like in the space of fast fashion, right? You can see like a high-end designer has created something, and then I can go on Shein and do the same thing, and it looks like, how does that work in fast fashion? Because I think too, like some of our designers, they see things and they recreate it, but it seems like it's like a free for all in that space.
Yeah, so you can't really protect the functional design of something. So you can't really patent or copyright anything a dress. You could copyright your actual drawings of the patterns of the dress, but that doesn't mean any use of that pattern is protected. It means the drawing of the pattern, how it's expressed, and the copyright is protected. So, or you could take a picture of someone wearing your clothes. The picture is protected. They can't, so a lot of times on like Instagram and stuff, people will, these like fake accounts will steal a creator's video and post it as their own and post links or whatever, probably to fake, merchandise to make money. That copying of the video is a violation of copyright. But the actual creation of the fake clothes, because I tried to kind of think about that. And so you can copyright the pattern. So you could do the design of the pattern, and we've actually had clients that do this. She's a fabric designer, and she designed a fabric, she hand drew the print on the fabric, and then a large retailer bought that design from another creator who had stolen our creator's work, and so there's copyright issues at issue there. So it's kind of like, you can't really just the item itself unless there's some sort of ornamental design you could patent, or some sort of your branding, like say you have a certain stitch or something on your clothes that's your brand, that you could trademark. So it kind of is, I think that's why a lot of the fast fashion stuff is kind of an issue right now, because it's hard to kind of figure that world out.
Nike, what did they did something with the Jordan 1? Are you familiar with that? Mm-hmm. The silhouette. I don't know I don't know if it was trademark, and Jordan's been around for a minute, but I think it was like 2 years ago when the one started blowing up. They copyrighted. I don't know what it was.
It might be. I saw they have quite a few design patents on shoes, so it might be something like that, because you can do like the ornamental design of the sole, or kind of any sort of non-functional aspect of the design or of the item you could pursue a design patent
and
for.
That protects that silhouette. So nobody, okay.
Yeah, I mean, again, it's a lot of just comparing and factual stuff. So obviously if you're holding yourself out to be Nike and you're not Nike, like you're gonna have a lot of issues there. So, but that's why some of that fast fashion stuff goes up and comes down so quickly, because they get in trouble. And so, but also if you're a small designer, you're not gonna be able to pursue all of these people, and it's expensive. And so, but like if you are a fabric designer and you're actually designing the picture on the fabric and the print, that's copyrightable. And you can also retroactively do it. So if you have one person that's consistently stealing your designs, pursue a copyright, send them some letters, stuff like that, then that can help. So that's the design patent. This is just other things to consider. This is like a very lawyer boring slide. I was going through my presentation and I was like, wow, this is really designed by a lawyer. But no, it's just straight to the point. But these are different things that aren't necessarily those main 4 types of IP, but they can provide you with some protection. So if you're going to go out and you're going to go talk to someone about your secret sauce, or you're going to go talk to someone about pursuing, working with them to manufacture your clothes or whatever it is you're doing, you're going to go talk to anybody about your business and you're going to go share anything, especially if they have the upper hand. If they're a bigger company, if you're one of many going in, you want them to sign an NDA. Now they may have you sign their NDA, which just read it and just kind of make sure that you're comfortable with what's in there. You might not have a lot of bargaining power, but you want to go, if you're going to share any sort of the inner workings of your business with someone that is not in your business, you want an NDA in place. They don't have to be complicated. Basically, you say, anything I share with you is confidential and anything you share with me is confidential. That's essentially what they are. And if stuff gets out, you have a recourse. So they can't, you're not going to go sit down at a meeting with somebody, tell them everything about your business, all your great ideas, and then they're going to turn around and say, actually, if we do it ourselves, we can do it for way cheaper, so we're not going to use you, we're just going to take all your ideas. If you've just given it all to them and you don't have an NDA in place, you're going to have a big problem. It's going to be way harder to get them to stop. So NDAs are a great way. If you do want to go in, you want to go talk to investors, you want to go do stuff like that, have an NDA in place. I would also caution you, I know a lot of people go and just like have a sit down lunch with somebody. Be careful. this is kind of like the just everyone's a friend until they're not a friend. And so, yeah. So just be cautious of what you're telling people freely without an NDA in place. It's one thing to bounce ideas off of each other, but just really be careful with just sharing too much because you don't want to get taken advantage of. Licenses, like you said, if you have trademarks or you have copyrights or you have patents or you just have ideas or your product, say you sell, or one of your things that you work on is videos of you explaining whatever, and you want someone to be able to use that, well, they can sign a license agreement. They can pay you to use that. And in that license agreement, you can tell them what kind of license they have. Is it a one-time use license? Are they able to transfer that license to anybody else? Are they able to say, yeah, we're going to use it, but then they send it to someone else who then sends it to someone else? And is that allowed? Is that okay with you? Because the farther it gets away from you, the less control over you have, how it's shown, all that sort of stuff. So licenses can allow someone to use something for free. They can allow someone to use something for money. So you can have a one-time fee. You can do royalties. You can do all that sort of stuff. So just keep that in mind as a way for to make revenue and to protect yourself, obviously. Another thing is assignments. So a license would be you retain ownership of the IP. If you assign something, which this could be another thing you could do with your patents, once you hold the patent, you can assign the whole patent to somebody else. So they could basically buy it from you. You assign ownership. You no longer have ownership, but you get something in return. So that's something that you can do. I would also say this can come into play if you have someone, so say you're, setting up your storefront and you want someone to come in and take pictures that you can put on your website. In the contract that you have with them, make sure that you own the copyright in those images, or at least you know how you're allowed to use the images, because you don't want to pay someone for something and then not be able to use it because they still have all the rights in it. So, or if you're on the other side of that and you're a photographer and you are contracted with people to go take pictures, make sure you know what you're okay giving away, whether it's a full assignment, whether it's a license, whatever you're comfortable with, and for how much money. These things, all this list is, a lot of it is kind of how you can use your IP that you've established to make some money. Terms of use agreements, if you sell or promote stuff online, just kind of be cautious of, so a good example of this is like you put up I saw one of these ladies I follow on Instagram, she puts out recipes for everybody. And what someone did is they started taking those recipes and making a cookbook. And those are her recipes. So she had this whole thing where she had to go back in and put a disclaimer on her website and say, these are only intended for at-home use. Like, these are mine. These are not to be, commercially used. Yeah, so it's just, and you don't even think about it until it happens. So hopefully this can at least kind of like trigger something in you to go, hang on a second, I think I need to think about this, and at least think through these steps before you end up in that position. Or if you do end up at that position, know that there's stuff you can do about it. Mergers and acquisitions, that's kind of a big one, but in a sale or an acquisition, you can obviously monetize your IP rights. That's kind of a whole point. If someone's going to buy your company, they're buying your goodwill, your branding, all of that. Even if it's not registered, it has value. So just keep that in mind if someone comes to you to buy your business, or if you're looking to buy someone else's business or merge or something like that. And due diligence, just if you are going to do any sort of business transaction where you're acquiring someone else or doing any sort of like, and this is not just business to business sale, but like selling the actual business, making sure that if they say that they own the trademark, go look at the trademark website, make sure they actually own it, make sure the assignment is in the database, make sure, just cross the T's, dot the I's. That's just kind of that. That's just kind of to think in the back of your head. And then, yeah.
So, because what's sticking out to me is, so in the spirit of collaboration and how I operate, I'm always like, let's go get coffee so I can tell you what I'm doing. And now I'm like, before I get coffee, it's like, could you sign this NDA for me? So it's like, really, we're just like, so right now we have a program that we're working on. And there are other players in the market who have similar things, but they really want to know, wow, what do you guys do? How are you doing it? You know, we would love to collaborate, you know? And so I'm like, yeah, let's go get coffee in July. But now I'm like, okay, Alicia, take a step back. Right? Because you're going to go in and share all the different things that makes your program or your experience unique. And they are a larger player. And they can more quickly change things from a communication and marketing standpoint. So what you're telling us, and I think too, Carrie, this might go back to your original question around kind of how trademarks and protecting your intellectual property is a part of innovation. We just have to be more intentional and aware that we have something that is worth protecting.
Yeah.
You know? So.
Yeah, and I mean, I never want to discourage people from going and having coffee and doing all of that, but just be cognizant of what you share. And if they say, well, how do you do that? And they're really dialing in on a certain point, and you're like, I'm not comfortable sharing this information with you because this is the key to my success, and I'm not ready to share that with anybody before I implement my key to success. So you can kind of, answer the question without answering the question almost. And just have it in the back of your mind, because you get so excited and you're like, I want to share everything. And then you're like, oh my God, I can't believe I just said that. So it's like, so I mean, I've totally been there, especially if it's over a glass of wine and not over a glass of coffee, you never know. But it's not that you don't want to share and you don't want to collaborate, because that's a huge part of innovation, is collaborating and working together, but just being cognizant of who you're talking to and how much you're sharing. And if it is something that you really think is going to be the key to your success, maybe just holding on to it for a little bit longer until you're ready. You can implement it. You can kind of see where you're at in the space before you go and share that with people.
Gotcha. So this may be on target or off. Pitch competitions are very popular for adults, for young people, etc. Just listening to some of the things you just said, might be odd, but let's say you have an idea or you're participating in a pitch competition to get funding, etc. Is it appropriate to ask that there be an NDA? What would you guide a person to do to protect?
Yeah, I would. So people in that space, I would hope, would be open to that conversation. And obviously there is this balance between, I need the money or this goes nowhere, no matter how good my idea is. And so you have to make that, determination. I would say, I mean, there are gonna be people in the audience that aren't gonna have signed the NDA. And so maybe there's something that when you sign up for this pitch competition, maybe you sign a contract and maybe it says in there something that you didn't know that you were giving up about your ideas, because that's the only way they can do this pitch contest. So I don't know exactly all the ins and outs of those, and I don't think that they're there for people to steal ideas, but you never know who's sitting in the audience and who's gonna say, oh, that would really go great in my business. And so it's something to consider. That's kind of the give and take of, I need this money or my idea goes nowhere, and maybe that person has the ability to do that. And I mean, it's like Shark Tank. They take, a portion of everything, but they give you what they'll give you.
So I question that kind of goes back to assigning a creative asset. So if I can assign something, what about leasing an asset, a creative asset? If we start this Apple, can Apple lease out its rights to create to another company? Maybe they've got a smaller company. Can they lease out, and have you ever seen that before, and does that make things messy?
Yeah, I mean, I think that would be a license. So they definitely, I mean, if you have the rights in something, you're free to license it however you want, with whatever limits you want. I mean, you could say you get to use this for 3 weeks and then see what you can do in 3 weeks and then you're done. Or you can say you have a perpetual, transferable, irrevocable license and you can do whatever you want with it. I don't care. But I still own the rights to it or something. I mean, you can make a license look however you want. So they could definitely do that.
Have you seen that before?
Not from Apple. But yeah, I mean, people definitely license their technology. I think a lot of times, like software, I think open source coding is bigger now. And that's kind of taking all of this away. They're kind of saying, we don't want to own the rights in this because we want to innovate. So that's the give and take there. All the open source coding is my understanding is you just kind of tack into it and you can do whatever you want. And so that's people who've taken it the other way and said, we don't want people to have their own rights in this software code. We want everybody to be able to do this. And so we're just going to have open source code. And that's another way to do it.
Yeah. Okay.
So do you have a question?
Yeah, so I'm trying to wrap my mind around like the real impact of communities or just ecosystems not doing this. Like we are familiar with lack of resources could do to the community with this. I know you might be familiar with just a ton of different things, things that directly affect communities' growth or innovation. But I'm trying to wrap my mind around like what does it really look like for just from conversations you've heard or just data you've maybe looked at or just anything you know for communities not to be doing it? Like where does that show up in the stagnation, just like these other things show up like that?
Yeah, I mean, I think a lot of times people don't realize the monetary value of their ideas, and you can get taken advantage of very quickly. You get bigger players in the market, they come in, they, make it sound like they're doing something wonderful for you, and they just take advantage of these smaller businesses that are like, oh my gosh, I can't believe they're going to pay me this much for this. And in reality, it's worth a lot more because that big company goes and, puts their big company money into it and takes off, and it's exactly what it was supposed to be from that small business owner, and then it's gone. And that's not everybody's story, but it could be anybody's story. And so I think that I think the NDAs are huge. I think if people relied on contract law a little bit more to protect themselves as opposed to trying to pursue the actual top 4, copyright, trademark, whatever, and just kind of focus on who you're talking to and protecting the discussion of the ideas and the sharing of information, that it doesn't necessarily have to be written down on a picture that you took and then you're going to copyright it. It's just your discussion is protected, and it gives you a recourse, and it gives you some bargaining power. I think people don't realize how much, if they come in to want to purchase your company, there's a reason they want that. And so I just think that if more people kind of understood that last slide and kind of the benefits of these different things, that could help that ecosystem a little bit more. But yeah, the NDAs, I always try and push on everybody because I'm like, I know it's a weird discussion sometimes, like if you're going to coffee. People always ask that, well, what do I do if I'm going to sit down with my friend? I'm like, well, I don't know. It's kind of like the whole prenup question. Yeah. Do you get a prenup or not? It's kind of up to you, and that's a contract, just like an NDA is a contract. That would be with your spouse. This would be with a friend. It just depends on how you feel about that relationship, and it's kind of a personal decision, and obviously it depends on the information that you're sharing and how valuable you think it is. So, and if they are your friend and it is super valuable information, of course, they would hopefully want to help you protect it. And so then they can get in on all the secrets if they're under the NDA. And this is just kind of a wrap-up slide, like why should you care? And I think we've probably touched on most of it, but, protect your creations, build and maintain your brand value. That's a big one, especially with, trademarks and stuff like that. Creating business assets that you're not necessarily looking at. It's not your physical good. Your ideas and your expression of those ideas are very valuable things, and they can be very valuable things. You can also avoid a lot of issues, especially with trademark stuff. If you just kind of do a quick Google search, it surprises me to no end how many people just pick a brand and go for it. And I'm like, did you look at anything? Did you put it in Google? Please. So just if you can avoid those battles, you'll be better off. Gain competitive advantage if you can get that brand, you can get it going, and you have all that goodwill behind it. Attract investors and partners, and then support business growth and expansion. You can obviously use your IP rights to help with your collaboration, helps you feel a little bit more secure in sharing, collaborating, all that sort of stuff. So
I gotta ask this question. So
yeah.
I've been using Apple as an example for a minute. How much would you say from a legal standpoint is money involved in fighting this thing? Like if I do get in a tangle with Apple over I came out with a product, oranges, and they want to brand oranges too. I might have been first, but how much would you say with the cameras off? Does money have to deal? You know what I mean? That variable. How big is that variable?
I think with bigger players in the market, they have a lot of money to fight that. And it's unfortunate. That's kind of probably what I would say one of the cons of this, IP world of protection is that it does push smaller players. It can shut you up real quick. Which is why I think, again, those NDAs and licenses and all those agreements, like fall back on contract law. You don't have to pay any money to, get a trademark and do all this grandiose, I have 7 trademark registrations. Okay, well, if they've copied one of your videos that was super helpful and super beneficial and that's what they made money on, then we've got to think about different ways to do that. And so I think that money, like, that plays a huge role in it. But it's also, I see a lot of it smaller business to smaller business. So it's not just big players in the market. I would just stay away from those brands. Stay away from Disney. Stay away from Apple. Don't make shoes with red bottoms. They will come find you. So it's just, but that's because they have put a lot of money and a lot of time and a lot of effort into creating those brands. And so that's the power of creating those brands. So it's just kind of a catch-22 almost. Yeah.
Question from a food product creation standpoint. I make a beverage using finished products that are Minute Maid, which I think is Coke, orange juice, and some clear drink, Sprite, whatever. But I do whatever to it. It has a unique taste when I finish. But I used finished products from these other companies. What latitude is there a latitude to say that this is something that is unique, or is it something that still remains attributed to those companies since their finished products were used?
No, once something has been sold, you can take that. Don't go put the Sprite label on it or the Coke label. Don't go do that and say this is a Coke product. But if you take all of those products and put it together and make your own product, then that shouldn't be an issue.
Because there's 7-Up making the 7-Up cake, right? Like the 7-Up cake. You ever had that?
7 pound cake.
Yeah.
Yeah, just don't put the label.
Can you get? Yeah. Can you get?
Just don't put the label on.
I wouldn't put a label on it that says 7-Up pound cake, but you can use sorry, I got something in my eye. But yeah, people sell bakery goods and, it's got milk and it's got whatever in it. And that's.
I was hoping it was kind of the same.
Yeah. Yeah. You wouldn't brand it as a Coke product.
Right.
Even if you're using all Coke products in the drink, don't brand it as Coke. Yeah. It's your brand. And you can't take a can of Coke and pour it into another can and brand it as something else and sell it. That's not going to work.
Yeah. Use it as ingredient.
But yeah.
To create a new thing.
Yeah. Yeah.
Yes, I have a question.
Yeah.
Couple of things about you were talking about clothing earlier. And you did a great job, by the way.
Thank you.
Yeah, you did a great job. So when you talk about that, do you have to know up front every item that you're thinking about doing? So
for the trademarks?
Yeah, so if you're doing trademarking on, say you're going to do an apparel brand and say you're going to have gym wear, like tanks, kind of think of, you think of the big brands like Lululemon and amongst other things, that style of wear. You're going to say, all right, I'm going to have an athletic brand, but I'm also going to have hoodies and I'm going to have t-shirts and maybe some jogging suits and things like that. Do you have to list every single item that it's going to show up on, or how far does that need to go? So,
and I'm going to disconnect this while I pull something up, just so I don't remember what's on my computer, especially since they're being recorded. So the answer is, it kind of depends, which I'm sure is the most legal answer you've ever heard.
That's the, I'm in finance, so
I'm not connected to the internet. I didn't think about that. I'm not connected to the internet, so I'm not going to be able to show it as quickly as I wanted to. But there's something, if you just kind of Google trademark ID manual, there should be kind of an interactive manual. It's not the most user-friendly thing, which is shocking. But if you within that, you can kind of put in what you're thinking about the description of your items to be. And I would say, like, you're considering the broader, the better.
Okay.
And so if you can, if you don't have to specify, if there's already, so when you're filing for a trademark, you can either file with the classes of goods or services that have already been used and are accepted by the trademark office and good to go. And those are, I think, $25 or $50 less than creating your own.
Okay.
And in this ID manual, you can kind of put in, like, you could type in gymwear and it'll give you kind of descriptions. It'll show you the class. It'll show you descriptions that are acceptable. And you can kind of see how broad you can get it. Because when you file a trademark application, anything that is in there on a use basis, so if you put t-shirts and sweatpants, you need to be using your mark on t-shirts and on sweatpants because you have to sign a declaration that says that you're doing that.
Okay.
So you can do t-shirts and shorts on a use basis and sweatpants and tank tops on an intent to use basis in the same application. That's okay. And then you have time to implement the other products.
But at the beginning, whatever you put in there, it needs to be active.
Yeah.
Got it.
Yeah. And then as you renew your trademark on whatever I forget the years, you again certify that it is still being used on every single thing in this description. And if one thing has changed, you're allowed to just remove that from your application. The whole application doesn't disappear.
Okay.
You just remove that one item from your description and you're good to go.
Okay, perfect.
And you can always add stuff for the new application. But yeah, you do anything that's written in there, you do need to be using it on there.
Perfect. So, the follow-up question.
Mm-hmm.
Say there's an abbreviation, right? So this is obviously a Tiger Woods hat, and there's a TW up here in a graphic way. So instead of the entire name of it, so say if you had a brand called Swim Place, whatever, you were selling shirts, but you made a hat, like a dad hat or whatever, and it had an SP on it. So does that have to be different, or is those one of those, you gave a term, I forgot what it was earlier, you have to give basically an example or a sample.
Oh, a specimen.
A specimen, there you go. That's what you
Yeah, so the specimen refers to essentially an image of something, the mark as you applied for it being used in commerce.
Okay.
So you would have to file a separate trademark on the abbreviated logo.
Logo. So it
Yeah.
would be one for the full and then a separate one for the abbreviation.
Yes.
Perfect.
And if you have, I'm trying to think of a good example, like,
Ralph Lauren would probably be a good example. They've got the horse, yeah, on the horse.
yeah, well, I'm trying to think of a different, okay, so the Target one. So, here it is. So for Target, there's different ways you can register your mark. So for Target, they probably have the word Target in black and white, just the words registered. That means you can use that word in any color, in any font, in any way, and it's protected. So for St. Patrick's Day, they could make Target in green, or breast cancer awareness, they make it in pink, or whatever, and they still own the rights to that. They, I'm sure, have also registered this bullseye.
Right.
They probably registered in black and white, which means they can use it in any color. They probably have also registered it in red because they have enough money, and why not? That's very distinct to them. So if color is a distinct part of your mark, then it's worth registering it in color. If not, if you're gonna register a design mark, I would highly recommend black and white because you have just broader protection. You can change your logo to different colors for whatever reason. And if you have words, so like, it's a bad literal mark, but the bagel shop with the thing at the top, the bagel at the top, if this were a better mark, they could register just the words the bagel shop and the whole design. So that means they can use the bagel shop. So say on their, bag they hand you with your bagel, they don't want to put that whole logo, they just want to write the words the bagel shop or get a stamp or something. That's protected. So there are different ways you can kind of make up your mark. And if you go, it's really helpful. I would highly suggest going to the trademark office website and putting in a major brand that you know and seeing all the different ways that they've trademarked their logo. Because that'll give you a really good picture of what you can do. And you can kind of go through all their applications and stuff.
My last question. So starting out, and this is, I wanted to ask this last because I was thinking maybe it would get there, but it validates my last question is starting out, if you're going to launch something in that vein, how far in this do you recommend from a legal perspective that you begin to go? Do you think you should go all the way federal. If you're just gonna say, hey, I'm gonna take my own money, I'm gonna self-fund this, and I'm gonna just try it out, I'm gonna see how it works out. Is that how far do you normally recommend that individuals go from a starting out perspective?
I mean, it's probably more so based on your risk level.
Okay.
And so if you intend to just stay small around Birmingham and that's, all you really want to do, or you can't think beyond that right now, then there's no point in spending another $325 on trying to do this application yourself. Do not spend the $325 without checking Google or the Trademark Office website, please. And I mean, there's a chance, like if you've picked something and you go on there and there's a whole bunch of other marks that are very similar and you think the Trademark Office might come back, I mean, it might be worth asking an attorney to do like a clearance search and see, is it worth even pursuing this mark, or am I going to pay more in attorney's fees trying to argue with the trademark examiner and I could just go pick something else because I'm still a super new company. So I would say when you go to register a trademark, be sure that that's the mark that you want, at least for the next few years. Obviously things change, but if you're still in the very beginnings of creating your business and your brand changes every day and the colors change every day and you're still going back and forth with the designer, do not register the trademark. So I mean, and it's also just, it does afford you some protection. It does give you a leg up. It's great when people come to us and they already have a trademark registration. But it's not the end of the world if you don't have it.
No, you answered
So
the question. That's helpful. Thank you so much.
yeah. And one thing, this is out on the table. So Bradley, the law firm I'm at, we have a pro bono clinic for Black small business and nonprofits in the community. And so there are income requirements and certain requirements of your business. But this QR code will take you to the application. And so we do a monthly free clinic. You can talk with a lawyer. If it's IP, it'll probably be me. Or we have a couple other partners that help at the clinic. But we also do just kind of general business formation questions, or if you need an NDA to go talk to somebody, that's a great reason to come to the clinic. We can give you a form NDA. Just kind of general basic business questions that can be handled in 30 minutes to an hour, kind of what the clinic is for. We have done some tax stuff that is kind of dependent on attorney availability because we only have one or two people that help us with tax stuff at the clinic. But we have them once a month, and feel free to sign up. Feel free to reach out to me if you have questions. We have a pro bono counsel at the firm, and so I work closely with her to make sure anybody that we can help gets help. So this is a great resource. It is free. If your question goes beyond the clinic, there's the potential that we can take you on as a pro bono client, but obviously we can't promise that. And if you do intend to sign up for a clinic and you have documents that you are going to be talking about or referencing during your call, please send them in advance so that we can look at them, because otherwise we're not going to be able to help you if you have all the documents. It's amazing the number of people that say, oh, I have this contract and this, and then they don't send anything. And it's like, well, we'll give you our first impression of it, but like if we had it before, we do have a little bit of time to prepare and we can come a little bit more prepared. But there are some form documents we can send you through the clinic, things like that. Or just if you are thinking of starting a new business, thinking of becoming a nonprofit, or just want kind of general information on that, it's a really good place. We have some really good attorneys that help us at the clinic. So
Thank you.
that's all I've got.